You also understand, sir, that there can be great peril in representing yourself. I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
What do you want to do with them?
I would like to suppress them so that they don't hinder my trial experience.
Okay, sir, it doesn't, you seem to want this process to work away. It doesn't. Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied. But I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that? You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. I'll grant your adjournment. Probable cause conference. Yeah, let me at least have some turkey before I have to deal with this again. December 5th. So, folks, if you haven't figured out why, I'm going to take a brief break. To understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said?
I comprehend what you're saying, Your Honor.
Tell you what, I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat. And you might want to wipe that smirk off your face while you're doing it. Sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges.
Not my question.
I recognize what you're saying, Your Honor. I'm fully prepared to proceed with this matter. I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer whether you understand what I am saying.
I overstand what you're saying.
Have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. Sir, listen closer to my question. Do you understand that?
I do not understand.
Whether or not you disagree with them or not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor. Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words "I understand"?
Sir, I'm not saying that you have to say anything. I am not going to play this game with you.
I'm not.
So what? No, you are playing a game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play this some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m. or I will. Do not interrupt me.
I can object to
do
that.
Do not interrupt. Do not. One more time. You're going. I've given you fair warning. Bond will continue. You
Your
may
Honor,
leave now.
I have constitutional.
You may
violation.
leave now. Let's go. Mr. Allen, he is to be removed from my court. Court does call the case of the people of the state of Michigan versus Daniel Magoo.
Your Honor, after the Lonnie, but people.
Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Magoo, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings, asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth. And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the board be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan
Yes.
that was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed include appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is something the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response.
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion or the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12 noon, that is before me.
Thank you, Your Honor.
And continue.